Welcome to Law and Life. This is Shashank Mishra as a host, present here with eminent senior advocate of Supreme Court of India, Subodh Markandeji. We will start from where we left in the last video. In the episode 25, we had discussed about the transfer of matrimonial cases by the Supreme Court of India. In the next episode, which is number 26, our discussion centered around the transfer of civil matrimonial cases by the High Courts and District Courts. In the episode number 27, we will discuss about the transfer of criminal petition cases by the high courts. And in the next episode, which will be coming in the later, we will be dealing with the transfer of cases and related matter by the session courts and magistrates. Starting this video with the question, what are the provisions for the transfer of criminal matrimonial cases by the high court?
Uh, Title of Chapter 31 of Code of Civil Procedure 1973 is Transfer of Criminal Cases. It contains sections 406 to 412. Section 406 deals with the power of Supreme Court to transfer the criminal cases which we have already dealt with in episode 25. Power of the High Courts to transfer criminal cases and appeals is dealt with in section 407. Section 408 relates to the corresponding power of the Sessions Court to transfer criminal cases and appeals. Section 409 bears withdrawal of cases and appeals by the Sessions Judge. Section 410 concerns with withdrawal of cases by judicial magistrates, and Section 411 deals with the making over of cases by the executive magistrates. Uh, so, uh, Section 412, which is common to all the sections 407 to 411, mandates that the sessions judge, the judicial magistrates, and the other magistrates shall record reasons for making any order under sections 409 to 411.
So my next question is, what is the extent and ambit of the power of high court to transfer the criminal petition cases and appeal?
So let's look at the purpose for which power can be exercised by the high courts, and then the extent of that power, that is to say what the high courts can do and its procedural aspects. So three matters, as I said. The purpose for which the high courts can exercise the power, the extent of that power, and the procedural aspects. So section 4071 provides that High Court can exercise its power thereunder when it is made to appear to the High Court that fair and impartial inquiry or trial cannot be had in any court subordinate to it. That's the first one. The second is some question of unusual difficulty is likely to arise. Then the third is an order under section 407 is required by any provision of the Code of Criminal Procedure and will tend to general convenience or is expedient in the ends of justice. Now, in the above in eventualities, this is what the High Court can do. The High Court can order that any offense is required, if any offense is inquired or trial by any court not qualified under sections 177 to 185, but in other respects competent to inquire into or try such offenses. It can order that it can be transferred to this kind of court. Then any particular case or appeal or class of cases or appeals be transferred from criminal court subordinate to its authority to any such criminal court of equal or superior jurisdiction. And thirdly, any particular case uh, be committed for trial to a sessions court. These are the three things which the High Court can do. Uh, or fourth is any particular case or appeal be transferred and tried before it, that is before the High Court itself. These are the four things which the High Court can do. So it will be noticed that the power of the High Court is very wide in extent and ambit, far more than just transfer cases. Subsection 2 provides that in acting under subsection 1 of section 407, the High Court may rely on the report of the lower court or on an application by the party interested or on its own initiative. Now, proviso to subsection 2 states that no application shall lie to the High Court for transferring a case from one criminal court to another criminal court of the same sessions division, unless such transfer petition has been made to the sessions judge and has been rejected. As per subsection 3, except where the transfer petition is made by the Advocate General of the state, every other transfer petition shall be supported by an affidavit or affirmation. So, except where the High Court is moved by the Advocate General of the state, in cases of other transfer petitions by the parties, the petition will be supported by an affidavit or affirmation. Section 4 provides that the High Court may require the accused making the transfer petition to execute a bond with or without sureties, payment of compensation, which the High Court may award under subsection 7. As per subsection 5, the accused, every accused must has to give notice in writing. That is, person making the transfer petition has to give notice in writing, together with a copy of grounds on which it is made or merits of the application. No hearing of the application can take place until at least 24 hours have elapsed since giving such notice. So that means that 24 hours notice, at least 24 hours notice must be given before a transfer petition can be heard. Now, subsection 6 empowers the High Court to be satisfied that it is necessary so to do to stay the proceedings in the subordinate court on such terms as the High Court thinks fit to impose. The proviso to that subsection, that is subsection 6, saves the subordinate court's power to remand under section 309 in spite of stay of proceedings by the High Court. So, remand can still be made in spite of the stay order. Now, by virtue of section 7, in cases of dismissal of transfer petition and the High Court coming to opinion that it was vexatious or frivolous, the High Court may compensate any person who opposed the transfer petition such sum not exceeding 1000 rupees as it consider proper. That is to say, in the case of vexatious or frivolous transfer petition, High Court can impose compensation up to 1000 rupees. Subsection 8 protects and preserves the power of the government of sanctioning the prosecution of judges, magistrates, etc. under section 197 of the code. So this is the totality of the power of the High Court. So we have dealt with the High Court, and we can deal with the other courts, that is to say the Sessions Court, the Judicial Magistrate, and the Executive Magistrate in the next episode.
Yes, sir. From here we will be winding up, and as sir told you, we will be discussing in the session courts and magistrate in the next video. Thank you for joining, everyone.
Thank you.